human rights workshop. It's amazing. It's already 52nd workshop. SSK Human Rights Forum, as most of you know, the inter-university collaborative research group on the human rights research from the perspective of social science. So SSK actually represents Social Science Korea, and we have been supported by the Korean government research foundation for the last 7 or 8 years, and various universities and professors are participating in this forum. From not only Korea University, we have Yonsei University, Ewha Women's University, Kyung-eun University, Sungkyunkwan University, and also foreign universities such as Harvard, University of Michigan, and University of Washington, etc. So it's sort of global research group on social science research on the human rights. So I'm a principal investigator. I'm really honored to lead this group, and also happy that we have provided these workshops so that students can participate in our efforts. So thank you for coming. It's so unfortunate that we didn't have many students, particularly from foreign countries, because most of them are doing their exams, Korean exams, to that. But anyway, I have a very special guest today. He joined the Human Rights Center just this month, a week ago. So I'm so happy. So I will just introduce her. She served for Korean government for a long time, from 1995 to 2017. And she joined us this month, and she continues her career as an individual expert on international human rights law. She was born and raised in Seoul and graduated from Seoul National University with BA in French education, which means that she speaks French very well.
Used to.
She earned the Master of Arts in Law and Diplomacy from the Fletcher School of Law and Diplomacy at Tufts. Now, this school is a really good school, particularly because I graduated from Fletcher School. And she received Ph.D. in International Law at Seoul National University, Graduate School of Law in 2017. She worked as the Deputy Secretary for Overseas Communications for President Roh Moo-hyun from 2006 to 2007, and in 2008, she stayed at the Henry Stimson Center in Washington, D.C. as a visiting fellow. She worked for the Ministry of Health and Welfare from 2009 to 2017 and was in charge of children's rights, tobacco control, and international relations. During her tenure as the Director of Child Welfare Policy, Korea made the most major changes in its legislation for child adoption since the establishment of its modern adoption law in 1960s. She also initiated the Korean government's plan to ratify the 1993 Hague Convention on Inter-Country Adoption. Her research interest lies in international human rights norms and its national implementation by states party to national law, policy, and practice. So she has a very strong view about the institutional flaws of Korea in terms of the child adoption. So I think that she will discuss that issue. So I'm looking forward to it. Let's welcome her.
Nice to meet you. And it was such a lengthy introduction of myself, so I would go directly on our discussion about today's topic. 이거는 how do I change the slide?
You can just give us about 40 minutes so that we can
Yes.
interact.
Okay. Today's title is International Legal Norms for the Rights of the Child and the Implementation Status in Korea. So this title contains basically, three parts. International legal norms on human rights, and the rights of the child, and national implementation status of these international norms. And I want to begin our discussion about this with three questions. The first one is international law. We keep on talking about international law, but this is law at all? This is my first question. And the second one is children's rights. We are going to talk about the children's rights. And is it equal rights or even real rights? Do we really believe it, or are we really taking it seriously? Or it's just a rhetoric? The third one, national implementation of international legal norms. The ultimate goal of international legal norms, the ultimate goal of the international law. The international law is not something, over the rainbow or in the clouds, up in the sky, but it's really on the ground. So the ultimate goal of international legal norms is the implementation of each specific countries through their national legal system. So I'm going to talk about that, but each categories, each topics, it deserves the whole session like this. So I think we are going to, we are trying to see some bigger pictures, compromising all these topics, and how the discussion about international legal norms, about human rights, are discussed in the international forum, in international institutions such as United Nations or Hague Conference Hague Conference on International Private Law. And there are so many international conferences, international forum that we are talking about international law outside of United Nations. But yeah, basically United Nations is really the biggest and basic forum about international law. And human rights and international legal norms, we are living in the 21st century, and most people agree on the universal human rights norms and principles, and we believe that they have legal effects, not just rhetoric. They have legal effects. But it is actually a very recent phenomenon. This discussion began with the establishment of the United Nations in 1945. It's just, it just began. We are living in the 21st century, but it just began in the middle of the 20th century. It's 70-something years ago. And this is the year that the World War II, the most devastating war in human history, ended. And UN Charter, the preamble of the UN Charter. UN Charter is like the Constitution of the United Nations. And this is, I think there are many human rights declarations and legal instruments, but I think basically this UN Charter is one of the most important legal instruments for the human rights. This preamble proclaimed the faith in fundamental human rights. The faith in fundamental human rights, and they decided to establish conditions under the obligation from treaties and other resources of international law. So this UN Charter is claiming that we are going to protect fundamental human rights through international treaties and law. And here you can see This is the website of the United Nations Human Rights. You can go to Google and just type International Instrument for Human Rights, and you can get to this site. And basically, you can get huge number of materials and instruments, documents about the United Nations Human Rights Treaties. And they are indicated 9 core human rights conventions. I think this is one of the most brilliant and
I like the colors.
yeah.
Easy
Yeah.
to read.
Do you think why I said these colors? Like this, different colors and different categories. It's kind of different categories. Can you guess? Anything? Okay, I will come back to this later.
I'm not going to give us an answer.
Okay. Later? Okay. So here's 3 questions. I'm going to back to these 3 questions. International law is law at all? International law is law at all? We think we are living in a civilized country and very under the leadership of very legitimate government. And as a citizen of a civilized country and legitimate government, we have, kind of mindset frame here, what is law? And I think that is like this, very simply like this. Legislation, there's a legislation process. It's done by the Congress. It's about setting the standards. We make the law by the Congress, and the Congress is composed of the representatives elected through democratic election. And there's administrative bodies which are in charge of the implementation of the law. And there's enforcement process by the judicial bodies. It is, when a violation of law occurs, it is dealt with by these judicial bodies, police, prosecutors, and courts. And we have a police and we have jail. So if someone violates the law, we have a power to enforce it. With this framework of national legal system, and we think of the international law, then it seems a little weird. We don't have international police. We don't have international jail. We don't have international court. Of course, there are some cases for wartime criminals, or criminals for crimes against the universe. Such a big name. In Hague, we have kind of court, and there is something we can call jail. But generally, this process does not exist in the international legal system. Then, what does United Nations have instead of that? That is the International Human Rights Treaty System, we call it. And this Human Rights Treaty System is developed by the United Nations by its rules and procedures to set the standards and to implement and kind of enforce its international law through this treaty system to its state parties. First, the most important role of the Human Rights Treaty is setting the standard. And we call it International Minimum Standard, which means that the poorest countries in Africa or the most affluent countries in Europe or North America, they can't abide by these standards altogether, international minimum standards. So it's actually, when it is set up in the conventions, human rights conventions, it means that every country, every member country of the United Nations, they agreed on it. 193 member countries, they agreed on those words of the provisions of the conventions. I think it's kind of miracle. And we call it international minimum standards. And the key point of its implementation of human rights treaties, I think it's this part. These conventions, this UN treaty system, they are not dealing with individuals. It is dealing with state parties. Treaty obligation is the obligation of state parties. And each state parties, they are really sovereign, the highest sovereign power in their own territory. So if we set up a minimum standards and made it as the obligation of state parties, and we can make these standards implemented through these state parties in those countries. That's the United Nations treaty systems, international legal system. And if you see the process, the treaty is established, the words of the treaty is established through the discussions in the United States by the expert groups, and it passed, it's established through the resolution of the General Assembly of the United Nations, and these conventions are all open to signature and ratification of state parties. And if certain number of state parties ratified it, and the treaty become effective as legal instruments. And the convention has national effect in those countries who ratified it. So there's a General Assembly, like the Congress doing the role like a Congress, and there's a process of establishment of human rights conventions. And if the treaty is effective, it means the state parties are voluntarily bound to this treaty. As I told you, these minimum standards, they are obligations of the state parties, not individuals. And these standards are implemented through the actions of the state parties, and the state parties, which is the sovereign power, which has the sovereign power in their territory, they are voluntarily bound to this treaty. This is the mechanism of the UN treaty system. And also for more, specific implementation, ensured implementation, enforcement of these treaties, we have periodic review by treaty bodies. This is, most commonly and commonly used and apparent system review by the treaty bodies. And there's committees and experts. They periodically review the country reports submitted by each state parties. And of course, we have individual petition courses and other tools for more, specific enforcement. But I'm going to skip this, and we are going to see just general factors about this. And so I wish I had answered that international is law at all. Yep. And my general answer was that it's not something like a national legal system. But the United States has, through its treaty system, has some tools to implement and enforce these international legal norms. And my second question is children's rights equal rights or real rights? There comes again these colors. These blue ones are kind of, they are they are general rights. We see here civil and political rights, economic, social, and cultural rights. All the general principles and specific rights are indicated in those in the provisions of these covenants. We can say it's general rights, and you see the green ones. That's the specific issues. Specific issues that the United Nations decided we have to deal especially. So they got the priority: race, torture, and enforced disappearance. And the red ones, they are special groups. Special groups, they are more vulnerable, that their human rights are violated, that they can come under discrimination. And those special groups, women, children, migrant workers, persons with disability, there is special groups, child. And on second thought, I want to ask a question. Child is really a special group. I would say that it's universal rights rather than specific. Because child is not a certain group of people. I mean, no human being can skip being child. For some period of time, every human being is child. And nobody remains a child forever. And if he or she survives 17 years right after the birth, he became full grown ups. And that's why I'm saying that it's universal rights, because it belongs to everybody, every human being. And so this right is not limited to a certain group of people. So some scholars call it as the right of childhood. It's the right, in order to clarify that it is not right of a certain group of people, but for certain period of time in the lifetime of a person. And this right needs special protection because every human being in this period is so vulnerable. And the core human rights we have to ensure during this vulnerable periods are, for example, rights to life. That's especially important for children. Just imagine, the small babies. And the right to be registered right after the birth. That's really, really crucial for the right to its own, his or her own identity. When it was violated in the very early childhood, that it cannot be recovered afterwards. It's impossible. So we make sure that such rights are ensured during this period, and right to have nationality, name, and right to education and right to development. These are the specific features of the rights of the child. And still, we should not forget that people under 18 is especially vulnerable group, and they need a special protection. And actually, the discussion of the rights of the child began with this special protection doctrine. It's 1924 League of Nations Geneva Declaration of the Rights of the Child. That's the first legal instrument that said about the children's rights. Is mankind owes the child the best it can give. It's such a kind of very sentimental wording, but this is after witnessing the devastating war of World War I. This right after the World War I. So it is always in war, disaster, or some very tragic events like refugees. Children were always the first and the biggest victims in those stories. And if we just stick to this special protection doctrine, we are at risk to forget that they are subjective life holders. And if we remain this, at this special protection doctrine, it's still, it means that we are still seeing them as objective, as objects that should receive what we want to give to them. But that's not right-based approach. And if somebody is a subject of right holder, subjective right holder, it means that they should decide what they need and what they want, what is their right. And the problem is that they are right holders. They are right holders, but they are incapable to exercise their rights on their own behalf. That's undeniable reality of the existence of a child. So, to fill the gap, to fill this paradox, we have best interest of the child principle. That's not just rhetoric. That's really legal principle and one of the pillar principles of the rights of the child of the United Nations Convention. And the simplest interpretation of this principle, the simplest interpretation is that is to give, because they are right holders, but they cannot exercise their right on their own. So we need somebody or some entity to decide its best interests on his or her behalf. And who decides? And how it is decided? Who decides and how it is decided? That's the main things, the main core factors of this principle, and the realization of these principles is the biggest homework of each national legal system of state parties. And this enters into more, legal discussions that is not very interesting, but at the end it is rule of procedures, which means that assessing and determining the best interest of the child through procedural guarantees. I want to skip this, but anyway, the procedural guarantees means that we cannot list what is the best interest of the child of every case in the substantive law. You agree with it, right? We cannot list in this case it's the best interest child, in this case it's best interest. It's simply impossible. So we set up, usually it's judicial review. We set up procedural guarantee safeguards for each individual cases can be assessed and determined. And that's usually in many countries legal system, it's a judicial review system. So the court's process, it is decided by the judges. So I have tons of stories to tell about, how this system is defective in Korea, but maybe for some opportunities. And I talked about that, to make children's rights equal and real rights, we need to accomplish and realize the principle of the best interest of a child in its national law and in its state parties' national law. So it is properly implemented is a really important question. All politics is local. Have you ever heard about this wording? All politics local. It is common wording in the U.S. politics, and it means that any leader any political leader say something, doing something in federal level, international level, in any actions or wordings. Ultimate goal is to win the local election. Wherever he speaks, he speaks to their voters, only voters. And I just try to paraphrase it in international law regime, or international law is national. The ultimate goal of international human rights law is to be realized in its own country, in the national level of each state parties. So the UN treaty body system, what they're really trying to do is that talking to state parties what they must do to ensure that all people enjoy their human rights in their own territory. That's the word of United Nations Secretary General. Actually, Ban Ki-moon. And so, since you are talking about the international law and the rights of the child, here are, core conventions that was established in the International Legal Forum about the rights of the child. 1989 UNCRC and 2 optional protocols about the state of a child and children involved in armed conflict. There are 2 optional protocols, each of these for these topics. And 93 Hague Convention on Intercultural Adoption. Optional protocols, you see here a new word. Basically, they are same as conventions. The establishment and ratifying signature process are the same. The difference is that conventions are dealing with more general things. UNCRC has 40 provisions, and each state's specified rights of the child. And these optional protocols are rather dealing with specific topics, like state of a child. One optional protocol is dealing with state of a child program, and the other optional protocol is dealing with the children involved in armed conflict. And Hague Convention is another international legal forum. Hague Conference on Private International Law. Actually, United Nations is the forum for public international law. But we are also need to dealing with the private issues, regulating private entities, like the members of the family, to protect the rights of the child. So this is really important. They have really important conventions for the rights of the child. Ratification. Korea ratified the UNCRC 1991. Actually, CRC is known as the most universally ratified convention in the world, in the UN history. 196. It's more than more than the total number of the United Nations membership country. 196 countries ratified this convention, but this can have dual aspects. One is children's rights is such a valuable thing. So which country can deny that to join this convention? And the other part is, it is so easy, so lightly treated, and they are not thinking about it so seriously to ratify this convention. They can be interpreted as 2 aspects. And one very interesting thing is that United States of America is the only country that does not ratify this convention among the member countries of the United Nations. So I think this is kind of problematic. And when Korea ratified this convention, they made many reservations. Reservation means that when they ratify, I told you why international law is law, because the state parties are voluntarily, they decided to voluntarily bound to this treaty. But the reservation means accept this. It means we are going to abide by this law, but accept this. We are not going to abide this. So that's the very easy way to get more ratification and more members to the convention. And so the Republic of Korea decided to make these reservations. And you know, when you see and these are all, you can see all the records of the reservations that the ratifying state parties made at the moment of the ratification. And you can see that Korea is the only country in the world that reserved this phrase, this provision. And this is very uniquely many reservations that a state party made when they ratified this UNCRC. So, which means Korea does not take it very seriously when they made the ratification.
Compared to other countries,
Yes.
I
Yeah.
think many, because except the United States,
Yeah.
every country signed it. So but they must have a reservation.
Yes, but reservations, but not this much, or not this, core provisions of this UNCRC. So some experts, some scholars say that these kinds of reservations should not be accepted by the United Nations. Problematic. And these optional protocols.
What is the content of the article?
Pardon?
What is the content of the article?
21 is about, this is the adoption clause.
Adoption.
Yeah. The adoption should be decided by the competent authority of the state parties. Competent authority means government bodies or judicial review. They should do this. But we are still not withdrawing this reservation. This is the only country in the world. And I have tons of stories about these reservations and declarations, but maybe next time if we have a chance to talk about it. And we have also this declaration. The declaration is very similar thing to reservation. And Hague Convention. Hague Convention is very serious convention. They don't allow reservation. And if you are to ratify this convention, you have to keep it completely or not. And if one state party have objection about about one state parties, if one of the state party thinks that this state party does not have appropriate national rigor system to ratify this convention, then between those countries, when they raise up, when one of the state party raise objection, does not have effective. So this is really serious convention. That's why Korea signed in 2013, but still not ratifying it. Yeah. Most countries involved in, more than 100 countries involved in intercountry adoption, they are all ratified. They have all ratified this convention. But still, Korea is one of the only main intercountry adoption country that does not ratify this convention. So, there are some more things that I have to say, but we already have, I think it's time that I should wrap up. I tried to say about how the national implementation of international legal norm is important. And we talked about the ratification process. Ratification process is entering to the convention. And what about the implementation? In this column, on the left side, you see the list of policies is deemed necessary in order to implement the treaty obligation of UNCRC. And this kind of idea examples, and this column, this right side, you see the list of the laws of exemplary legal system dealing with the system of the left side. So to properly implement UNCRC in your own country, you need this set of policies and laws. Usually, ideal legal structure have this picture. This is a private law, like family relations that you can decide on your own. And this is public part. The government intervene into private part to protect the rights of the child. This is ideal legal structure of national legal system to implement national legal system of state parties to properly implement UNCRC. But in many cases, this is the picture. This is private part, and this is public part, and there is a huge vacancy. And the legal vacancy between this private law and public system, children, the rights of the children became extremely vulnerable. So, if you want to find out if certain legal system is like this or like this, we should see very detailed aspects of its national legal system. And finally, I think I put some wrong name of the optional protocol because UNCRC now have individual petition optional protocol. We thought that children cannot do individual petitions, so I think this is the wrong name. Have individual petition, but now they established to allow children to raise individual petition to the UN Human Rights Commission. And they have another guidelines for the alternative care of children, and Hague Conference has many many conventions on child support and family relations. And I want to show this. This slide because in 21st century, because all the development that I mentioned here is the development in 20th century, and in 21st century there is a really bigger and very accelerated development of the legal instrument in regards to the right of the child. But the problem of Korea is that we are not properly implementing 20th century's international legal standard in our country. So I hope that this is going to be a quick review for the better understanding of the legal structure, international legal structure about the rights to protect the right of child, and we'll try to see what's the reality of Korea and the implementation status of Korea, and how we should go further, one step further, to make it a appropriate implementation, to make better implementation standards in our own country. Thank you.
Okay, thank you. Okay, thank you.